the Supreme Court will be taking up a gun rights case.
Members of the Senate are focusing on gun rights in the wake of the Supreme Court's Bruen decision.
The U.S. Supreme Court has just issued a major ruling.
This is a case that's been bounced around back and forth throughout the court system.
Back here in the U.S., the U.S. Supreme Court is hearing arguments on a $10 billion lawsuit.
And Republicans are pushing to get a new version of what they call the Second Amendment Preservation Act passed.
On its opening day of the new term, the U.S. Supreme Court rejected Missouri's bid to revive its law aimed at declaring various federal gun restrictions unconstitutional in the state.
A single word just destroyed what could have been the biggest victory for gun rights in modern American history. 8 Supreme Court justices, including conservatives, voted it down. 1 justice stood completely alone, and the aftermath is exposing a constitutional battlefield that most Americans don't even know exists. This wasn't your typical Second Amendment case. This was about something far more explosive: whether states can actively resist federal gun laws without being crushed by Washington. Missouri thought they found the perfect legal loophole, the same strategy that sanctuary cities used to block immigration enforcement for years. But they made one catastrophic mistake that turned their attempted victory into a constitutional disaster. Let me walk you through what actually happened here, because the implications go way beyond guns. Missouri lawmakers didn't mess around when they passed the Second Amendment Preservation Act. They wanted to stop federal agents from enforcing gun regulations in their state, period. So they created what essentially became a financial bomb that could destroy law enforcement careers overnight. The penalty, $50,000 per violation. But here's the part that made officers break into cold sweats. This wasn't a one-time fine. Each individual case counted separately. Think about what that means. A sheriff who cooperates with federal agents on just 4 investigations faces $200,000 in personal penalties. We're talking about fines that are triple the average annual salary of Missouri law enforcement. And it got worse. Insurance companies looked at these penalties and said absolutely not.
For the Supreme Court, it's all about language: reasonable suspicion, objective reasonable belief, or probable cause.
Last week, representatives from police departments in Branson, Rolla, and others testified against it.
Everybody has a right if they're a responsible adult.
My response to that is that's the same claptrap that they have been using for 20 years.
The right to keep and bear arms shall not be infringed.
They classified cooperation with federal agents as intentional violations of state law, which meant no coverage whatsoever. Every single dollar would come directly from the officer's own pocket, their savings, their home equity, their retirement funds. Within 6 months of this law taking effect, 47 lawsuits had been filed, not against criminals, against police departments, by citizens. County budgets started bleeding money faster than anyone anticipated, and officers found themselves trapped between 2 impossible choices: violate state law or refuse to cooperate with federal agents. Here's where this story takes a fascinating turn. Conservative attorneys didn't invent this strategy out of thin air. They stole it directly from progressives, and for years it worked brilliantly. Between 2015 and 2021, over 560 cities and counties declared themselves immigration sanctuaries. They blocked ICE agents from accessing local jails, refused to share government database information, and stopped using any municipal resources for federal immigration enforcement. The Justice Department threatened them. The media debated it endlessly. But legally, the sanctuary cities won. San Francisco stopped honoring ICE detainer requests entirely in 2015 and faced 0 legal consequences. New York City went even further, passing laws that prohibited city employees from even asking about immigration status. They created an information blackout that crippled federal operations, and the courts upheld their right to do it. The constitutional principle behind all of this is called the anti-commandeering doctrine. It's simple but powerful. The federal government cannot force state and local governments to enforce federal law. The Supreme Court affirmed this repeatedly. Conservative lawyers watched this play out year after year and had an epiphany. If states can't be forced to help ICE enforce immigration law, then states can't be forced to help the ATF enforce gun law either, right? The logic seemed airtight, but there was one critical difference they missed, and it would prove fatal. Clarence Thomas has cast more solitary dissents than any other sitting Supreme Court justice. 73 times he stood completely alone against the other 8 justices. This Missouri case marked number 73. What's remarkable is that Thomas didn't even write a full dissent this time. He simply noted he would have granted Missouri's stay request. In Supreme Court language, that's significant. It means he believed the other 8 justices missed something fundamentally important about how federal and state power should interact. Thomas practices what legal scholars call strict originalism. He's willing to overturn precedents that have stood for over a century if he believes they contradict the Constitution's original meaning. His judicial approach gets compared to Justice John Marshall Harlan, who stood completely alone in his dissent against Plessy versus Ferguson, the 1896 case that upheld racial segregation.
And today, the Supreme Court has answered that question.
So the Supreme Court has issued an order in the critical Second Amendment Preservation Act challenge that was pending in front of their court.
It triggers something in me that something has to be done.
Justice's ruling this morning, it conflicts with the Second Amendment's right to bear arms.
There is a difference between states deciding how they want to regulate any number of things versus stripping people of their rights to self-defense.
Saying setting a higher threshold in an emergency could mean life or death.
Harlan was vindicated 58 years later when Bruen versus Board of Education overturned that decision. But here's what most people miss. Thomas's vote in the Missouri case wasn't really about protecting gun rights at all. It was about something far bigger, the fundamental structure of American federalism and how much power states retain against federal authority. His vision would have reshaped the entire relationship between Washington and state capitals. Meanwhile, gun rights advocates were already winning their battles through a completely different strategy. On June 23, 2022, the Supreme Court issued the Bruen decision, and it changed everything overnight. The Bruen standard threw out decades of established Second Amendment law and created a revolutionary new test. Any gun regulation now has to be consistent with America's historical tradition of firearm regulation from the founding era. Federal judges suddenly found themselves researching musket regulations from the 1700s, dueling laws from the 1800s, and frontier gun policies from the Old West. Within 18 months, over 450 federal and state gun laws faced court challenges using this new standard. The success rate for gun rights advocates skyrocketed from 23% to 67%, a complete reversal that stunned legal experts. Gun rights organizations poured $89 million into lawsuits using the Bruen standard, and they won far more often than they lost. The Bruen decision was systematically dismantling gun control laws across America through the federal court system, which raises an obvious question. If gun rights advocates were already winning this war through traditional litigation, why would Missouri risk everything on an extreme state law that directly challenged federal authority? To understand Missouri's panic, you need to understand what the ATF has been doing. In 2023 alone, the Bureau of Alcohol, Tobacco, Firearms, and Explosives conducted 37,872 compliance inspections of gun dealers. That's a 340% increase from 2016. These inspections resulted in 122 federal firearms licenses being revoked, effectively destroying gun stores for what owners claim were minor paperwork errors rather than actual criminal activity. One gun dealer in Oklahoma lost his license after ATF inspectors found discrepancies in 3 out of 14,000 transaction records. The owner insisted they were simple transcription mistakes that posed no public safety risk. Didn't matter. The ATF has also wielded regulatory authority to reclassify items without any congressional approval. They declared bump stocks to be machine guns in 2018, forcing over 520,000 owners to either destroy their legally purchased devices or face federal felony charges carrying up to 10 years in prison. Most controversially, despite explicit legal prohibitions against creating a federal firearms registry, the ATF maintains a database containing over 920 million firearms transaction records at their National Tracing Center in West Virginia. Missouri legislators looked at these numbers and saw federal agents with the power to redefine legal products as felonies overnight. They panicked, but their solution walked straight into a constitutional trap that has existed since before the Civil War.
Give us transparency in how you're going to handle them, and if there's a roadmap of what you're going to follow that's more clear, then it's going to be a fairer process for everyone.
This case could reshape how far states can restrict your right to carry and where.
You couldn't get a firearm and carry it just because you wanted to be protected against criminals. We won't see changes overnight, but it's going to be quick.
Major Supreme Court ruling.
It's a case that legal experts will be watching closely.
The single word that destroyed everything. Article 6, Clause 2 of the Constitution contains just 68 words known as the Supremacy Clause. Federal law is the supreme law of the land and overrides conflicting state laws. Pretty straightforward. But here's where Missouri's case becomes absolutely fascinating. They weren't actually trying to override federal law. They were using the anti-commandeering doctrine that the Supreme Court has repeatedly affirmed. States cannot be forced to enforce federal law. The court established this principle in Prince versus United States in 1997 when they ruled the federal government couldn't require state law enforcement to conduct Brady Act background checks on gun purchases. Missouri's attorneys thought they were on solid constitutional ground, but they made one fatal error in their language choice that transformed everything. The Second Amendment Preservation Act declared federal gun laws invalid within Missouri's borders. That single word converted their law from constitutional non-cooperation into unconstitutional nullification. It's the same doctrine Southern states attempted before the Civil War when they claimed authority to void federal laws within their territories. 8 justices saw that nullification language and refused to even consider Missouri's arguments about anti-commandeering or state sovereignty. The legal strategy that seemed bulletproof shattered against a constitutional principle that was settled over 150 years ago. The Supreme Court just set the boundaries for how far states can push back against federal power. But multiple states are already rewriting their laws, carefully crafting language that might avoid Missouri's fatal mistake. They're learning from this failure, and the next challenges are already moving through the courts. This case reveals something crucial about the current state of American federalism. The tension between state and federal authority hasn't disappeared. It's intensifying. And gun rights have become the new battlefield where these fundamental questions about power and sovereignty are being fought. Whether gun rights expand or contract in your state over the next decade may depend less on public opinion or even election results, and more on whether state legislatures can thread the constitutional needle that Missouri missed. One word made all the difference this time. Next time, the stakes might be even higher. That's it for today, folks. See you in the next video.